would be great if you could wait. It would be great if you could wait to the end, but you can also drop them in chat, and I will try and kind of capture them as we go. We are going to record this, so if you want a copy afterwards, let me know, and we can make it available. All right. So with that, let's get started. Here generally are the topics that I intend to cover. I first intend to go over some federal initiatives that we're aware of and different events at the federal level. Some aren't necessarily laws that have been passed, but deal with laws and deal with other issues. And so that's first up would be the federal initiatives. We would then take a look at state legislation that passed, and there's basically two acts that we would be looking at. Amendments to the Elliott-Larsen Civil Rights Act, and then a Brownfield Redevelopment Financing Act. That one sounds super exciting, I know, but I'll kind of get into why it's there once we get to it. There are also several bills that are pending currently in the state legislative session that we're paying attention to and tracking. Those are listed on the third bullet point, HB 5019 related to reserve studies, HB 5028 related to a homeowner's energy policy, and then a couple bills related to some resort associations, and then the construction payment acts at HB 4837 and SB 451. And then after taking a look at the bills that are pending, we'll also take a look at some of the state legislative initiatives that are either coming up or are relevant, and that could lead to legislation still yet in this session. So first up, the federal initiatives. The first one that I wanted to cover, and we've actually kind of addressed this a couple of different times because this has been going on since the Surfside condo collapse in Florida back in 2021. But it's the Freddie Mac and Fannie Mae response to concerns that were raised over the lender questionnaires that Fannie Mae and Freddie Mac have been using to determine whether a loan is warrantable or unwarrantable. As you may know, Fannie Mae and Freddie Mac are major backers of mortgage loans in the United States. Something like well above 80% of all mortgage loans go through a government-backed entity such as Fannie Mae or Freddie Mac. And so a lot of borrowers and a lot of buyers use those loans in order to purchase units, both in subdivisions and in condominiums. And just generally, those are a good source of funds. They tend to be lower interest rates, and depending upon underwriting guidelines, they can be used by borrowers to purchase units. One of the things that Fannie Mae and Freddie Mac have done is they've taken the position that in order to address the concerns arising out of Surfside, that they are going to limit the use of loans that they back and prohibit the use of their funds for the use of purchase of units in condominiums that are in need of critical repair. And this has been something that they've been ongoing for a while. In 2023, though, the aspect of it that is new is that in mid-2023, in July, both Fannie Mae and Freddie Mac adopted in Fannie Mae, it's a seller guide announcement. In Freddie Mac, it's a servicer guide bulletin. But they updated their underwriting guidelines to basically incorporate in large part those temporary provisions that they had adopted in 2021 in order to address how critical repairs would be considered. One, if an association or a community is in need of critical repair, they likely are not going to be eligible for a loan, but they also specified how they're going to be gathering that information. Still through the use of what are called lender questionnaires. A couple things that I wanted to point out to this, although this does—
Oh, I forgot to turn the volume up.
I would ask if you could mute yourself. I'm trying to catch those as I've seen them, but once you come on, please take a look and just try and make sure you mute it. But a couple things I wanted to point out with respect to the Freddie Mac and Fannie Mae responses are that, one, condominiums in need of critical repairs or have significant deferred maintenance are not going to be able to qualify for loan, which is going to reduce the market of individuals who are able to purchase a unit within that condominium, potentially having a negative effect on the value of the units in that condominium. In addition to defining what critical repairs are, these 2023 updates also defined what are considered routine repairs, and routine repairs would not be considered critical. A couple things I wanted to point out in addition to that is that the 2023 guidelines create what is called an unavailable status for condo projects. In some places, this has been called a blacklist, but basically what this amounts to is that if in an underwriting guideline, Fannie Mae, Freddie Mac deem a particular project unsuitable for loans and put it on the unavailable list, then future purchasers and future mortgagors will not be able to be eligible for a loan under Fannie Mae and Freddie Mac underwriting guidelines if that condominium remains on the unavailable list. So that's something to watch out for and kind of see what happens with that. One other thing I wanted to point out in this is that since the underwriting temporary provisions had been adopted in 2021, and since the lender questionnaire had been put out by Fannie Mae and Freddie Mac, Fannie Mae and Freddie Mac had been under some scrutiny in an effort to try to make it easier for associations to answer the questions that are on the addendum to the questionnaires. And one of the things worth noting is that when the July 2023 guidelines came out, Fannie Mae, the head of Fannie Mae, also put out a statement at the time that explained what they were doing. And to me, it looked like they were actually explaining it in a way to say, look, these are things that are important. We understand these are going to be burdensome, but we're basically sticking to our guns on requiring that this information is being provided. And the language that they used is the bullet point at the very bottom. And they said that the purpose of the 2023 updates was to, quote, to protect lenders in Fannie Mae from a risk management perspective, but also to protect borrowers from physically unsafe or financially unstable projects, end quote. And to me, the significance of that is that that's them saying, if you have a community or a condominium that has critical repairs or has significant deferred maintenance or isn't adequately funding the reserve fund in order to be able to avoid significant special assessments in excess of $10,000 per unit, that Fannie Mae and Freddie Mac have made a decision that it's going to be very difficult for individuals to obtain funds in order to buy from them in order to be able to buy a unit with that condominium. So not necessarily a law that came out, but it is some clarity that was provided and basically maintains the position that Fannie Mae and Freddie Mac have had at least since 2021. With respect to federal legislation, there are a couple things worth noting. First is a pending bill, and this also comes off of still the Surfside condo collapse that took place, that occurred in 2021. In 2022, there were two bills that had been introduced. The Safer Condos Act, which is HR 7532, and the Rapid Financing for Critical Condo Repairs Act of 2022, which is HR 8304. Both of these bills were intending to try to make it easier for either the association or a homeowner who had to pay a special assessment to obtain financing for the purpose of being able to pay for critical repairs that were needed by a particular condominium or a community. Neither of those bills passed. They died at the end of that legislative session. And so as a result, in 2023, there was a new bill that was introduced taking, I don't know who comes up with these names, but there's probably like a mini market for coming up with creative names at the legislative session. But the name of this bill is the Making Condos Safer and Affordable Act of 2023. Similar to the Safer Condos Act and Rapid Financing for Critical Condo Repairs Act 2022, this bill would expand access to public and private loans for structural and safety repairs within a condominium, and would authorize the backing of mortgages that are used to finance both repairs in the community and from the owner's perspective, the repayment of special assessments for repairs. So these are some efforts at the federal level to try to assist communities in getting the funds necessary to make repairs. It's like the flip side of the coin related to the Fannie Mae and Freddie Mac issues, where Fannie Mae and Freddie Mac are taking kind of a hard line, but whereas there is a recognition by some legislators of the need to expand the access to financing in order to make those repairs that are necessary to get back to a warrantable loan status. The other one at the federal level that I wanted to mention is the Corporate Transparency Act. And you may have heard a lot about that recently, kind of at the end of 2023 and beginning of 2024. There's been a lot out there about this. The Corporate Transparency Act went into effect for associations that are formed or created in 2024. It's gone into effect. And so any association, if there are any property managers on the call, any association that you have that's been newly formed in 2024 is going to need to comply with the Corporate Transparency Act in 2024. For associations that are already in existence, so if you have an association that's been around or formed prior to 2024, then that effective date is going to be, it'll need to be in compliance by January 1st, 2025. As a practical matter, what this means is that they'll probably do their first filing towards the end of 2024, once the 2024 board elections take place. But to give a little bit of background for what the Corporate Transparency Act is and what it's intended to do, this is really an effort by FinCEN, which is I can never remember the acronym, but basically it's a federal agency intending to prevent financial fraud and tax fraud and money laundering in the United States by corporate entities. The significance of it and what's supposed to happen is that corporate entities in the United States, including condominium and homeowner associations, are required to file what's called a beneficial ownership information report using a FinCEN portal, under which the corporate entity identifies all beneficial owners. And even though most community associations are in a membership ownership structure, beneficial owners include officers and directors. And so there are certain timeframes that these need to take place. But the obligation here basically is on an annual basis, and then with a certain period of time after there's been a change, corporations are supposed to file this information with FinCEN to identify who their beneficial owners are. Changes, so hypothetically, once things are underway and in place, if you have board elections and you're within the effective period for your association, then changes to the beneficial owners, meaning a change in the identity of your officers and directors, are supposed to be reported using that portal within 30 days. There are significant penalties for non-compliance. The stated penalty has a civil penalty of $500 per day with a $10,000 cap. And for individuals that submit false information, there's the potential for 2 years of imprisonment. So pretty stiff penalties for non-compliance. And this is something that we've tried to take a pretty active role in communicating to our clients, but it's something to watch out for and follow through with in 2024. Now, there is an effort that I wanted to mention at the federal level to exempt or attempt to exempt community associations from being bound by or obligated to follow CTA. That has not passed. There's also been an effort within the U.S. House to delay the CTA by another year, although that passed the House by a 400-to-1 number, and so a pretty easy majority. That's still pending in the Senate. And then there's another group of 80 legislators who have requested that CTA be delayed by at least 1 more year. However, as of today, the CTA went into effect. It's applicable, it's binding. New associations need to follow it in 2024. And then again, for all associations, by the end of this year, you really should have filed your first annual submission in order to clarify and provide FinCEN with the information being requested, which is going to end up being a lot of specific information about the identities of the beneficial owners. So that's the Corporate Transparency Act. If there are questions, I'm happy to do my best to try to answer those when we get to the end. So with respect to Michigan legislation, there's basically 2 acts that I wanted to cover on this. The first one is an amendment to the Elliott Larson Civil Rights Act. So this passed in May of 2023. There was a law that was passed, SB 004, which is assigned 2023 Public Act 6, which probably doesn't mean a whole heck of a lot from a as you consider it. But the significance of it is that the this change amends the Elliott-Larsen Civil Rights Act to specify that a protected category within the Elliott-Larsen Civil Rights Act includes the concepts of sexual orientation and gender identity or expression. What this means is that any prohibited discrimination or any category within the state of Michigan of discrimination that would be prohibited would include discrimination based on sexual orientation and gender identity or expression. Now, these concepts had been in play already because of certain rulings that had come about, but this was a codification of that concept, basically establishing in Michigan that discrimination on those bases would be illegal under the Elliott-Larsen Civil, or prohibited under the Elliott-Larsen Civil Rights Act. And it's here because it has a broad impact on society, including real estate, sale of real estate, and will affect community associations. So you may already be aware of that. You're probably already following that, but just something to keep in mind. Another one that I wanted to mention is the Brownfield Redevelopment Financing Act of 2023 PA 90. So the reason this one is here is it does not have necessarily a direct impact on community associations. You know, it's not going to have an impact on management as a co-owner. It's not necessarily going to have an impact on you with respect to how you function or the things that your association can do or not do, or what its obligations are. So in that sense, it's unlike, you know, the discrimination concept of the amendments to the Elliott-Larsen Civil Rights Act or the obligatory filing concept of the Corporate Transparency Act. But the reason it's here is that brownfields in Michigan have up till now been able to be used for certain purposes, but did not necessarily include housing activities. And so with the amendment to the Brownfield Redevelopment Financing Act, developers will now be able to use a brownfield tax increment financing using a brownfield in order to capture, subject to approval of the brownfield itself, in order to capture the increase in tax revenues that would come out of their proposed use of the property. The possibility is that there may be will improve access and increase access to housing in the state of Michigan in theory, and it may create the opportunity or existence of associations to be formed in brownfield areas. So nothing necessarily that an association will need to do with this, but just a recognition that there's another vehicle for tax increment financing and an increased opportunity for available housing in the state of Michigan. So those are, at least when I was taking a look at it, those were the two laws that had passed that I thought were worth mentioning for this, in that were significant or potentially significant to community associations. Now in Michigan, the legislative session, like at the federal level, operates in 2-year sessions. And right now we're in the midst of a 2-year session. So the current legislative session goes from 2023 to 2024. Which means that any bills that had been introduced in 2023 are still pending. Any bills that had been introduced in 2021 or 2022 are gone. You know, they did not pass. If they, you know, they've been dropped and they're no longer on the table, basically, if they had not been adopted prior to the end of 2022. But anything that had been introduced in 2023 is still there and has the opportunity for passage in 2024. Anything that is introduced in the 23-24 session that does not pass by the end of 2024 will need to be reintroduced in 2025 for it to be in play. So that's just a little bit of background and the stage that we're at with respect to the current legislative session. So with respect to those things that are pending, there's a handful that I wanted to talk about. The first one is one that we're generally supportive of, and a number of attorneys have had a significant role in trying to get going, And that's HB 5019, which is basically, I've coined a reserve studies bill. This was introduced in fall of this year, September 9th, actually it may still be summer technically, but introduced September 19th, 2023 as an amendment to the Condominium Act. And in essence, what HB 5019 would do is it would require condominium associations that have a budget of a certain over $20,000 in order to, one, obtain a reserve study within 3 years of the act's enactment, and thereafter to conduct a reserve study or have the reserve study updated every 5 years thereafter. It would also establish minimum standards for conducting a reserve study. It would require a board to adopt a reserve funding plan. It wouldn't obligate an amount, but it would obligate the adoption of a plan. And then it would require a board to provide certain notices to the co-owners related to the existence of the reserve study and the reserve funding plan itself. The goal with this particular bill is to try to equip associations and their boards so that they know what the actual costs are, what the true costs are for maintaining, repairing, and replacing those physical components and the capital improvements within that condominium. And to not necessarily not require a certain amount, but to require that the board give thought to what its reserve funding is going to be and its reserve funding plan is going to be in light of a reserve study. So that's the goal behind it. That is still pending. It does appear to have support with respect to the legislators that we've talked to about it, but it has not advanced out of committee and is still pending. There are a couple things I wanted to mention in the reserve study bill. Yes, it requires the board to go out and get a reserve study, but ultimately what its goal is that the reserve study is used as a tool to try to allow the board and the association to effectively plan for having funds available to match the cost of maintaining that community. And so 1056 and 1057 are two provisions that I wanted to highlight and call out. Under 1056, which is the creation of a reserve funding plan, a board would be required to establish a reserve funding plan in accordance with the reserve study and communicate the funding plan including any changes to the association of co-owners in writing. Now, the reserve funding plan could be based upon savings. It could be based upon the concept of and anticipating borrowing, and it could also be based upon special assessments. It's really up to each community, or would be up to each community, to come up with their own plan. The concept here, though, is that that plan, whatever it is what is communicated to the co-owners. And that's really the impetus behind it, is to try to create an informed community. Now, you can see in 1057 that the taking into account the reserve fund itself, it's got to be adequate, taking into account what's already in the fund and whatever's done in advance in order to be able to pay for what is needed for repair and replacement of the common elements. So that's the reserve studies bill. We'll see what happens with it down the line. We expect to know more about its likelihood of success still yet in this first quarter of 2024. So on the flip side, if we're generally supportive, conceptually at least, of the reserve studies bill, on the flip side is HB 5028, which is called the Homeowners Energy Policy Act. When I was in college, I had a friend who was an intern, and he said, Matt, whenever you see a name of a bill, usually it means the opposite of whatever the bill is called. And that was kind of a jab at those that adopt it. But I thought about that concept when I saw this term, the Homeowners Energy Policy Act. It's not necessarily the opposite, but it has a pretty significant negative impact on community associations. There's basically two concepts that, from my standpoint, I think are problematic. First, just so you know what this does, one of the main provisions of this bill is that it would invalidate and prohibit any provision in the governing documents of a community association that have the effect of prohibiting the installation of a solar energy policy. And it renders it or a solar energy system, excuse me, and it renders it invalid and unenforceable as contrary to public policy. So it establishes as the public policy of the state of Michigan that community association boards of directors and their architectural control committees are without the ability to deny a solar panel within the state of Michigan, assuming this passes. Now, this does not, in theory at least, this doesn't apply to a shared roof situation, but in our view, the language used to try to exclude a shared roof situation and exclude its applicability to a condominium setting is not well drafted, and there's still significant risk, not just to the homeowners in a single family home type setting, but also to condominiums that may have a townhome style that has a roof above a unit or a site condo situation. And there's basically two overarching problems that we have. One I've kind of already alluded to, which is the architectural control issue. It basically removes from the board of directors the possibility of being able to weigh in on the adequacy from an architectural standpoint of a requested solar panel installation. And the other aspect is that we think that this bill is not very well drafted. It appears to have been cobbled together from a couple different sources. And one of the big problems we have with it is that this bill does not consider the impact or the possibility of the association's obligation to maintain a roof. So if in many communities, the association itself has the responsibility to maintain, repair, and replace the roof. It's the association's responsibility to take care of it. Well, what this bill would do is, regardless of whether it's the association's responsibility to take care of the roof, and regardless of the possible impact of a solar panel installation on a roof warranty that may have been obtained for that roof, if it is not a shared roof situation, that association at present has no ability to tell the owner that it cannot be done. And so in our view, HB 5028 as currently drafted creates confusion in determining the impact of the installation of the solar panel on the obligation to maintain and care for that roof, because it does not specifically say that it's that co-owner that's going to be responsible, or that the association can prevent it if the association is responsible. So those are a couple of things that we're trying to get cleaned up if it's going to go forward. It did have significant support. It passed the Michigan House in November, on November 1st, 2023. Significantly, it passed the Michigan House because basically along party lines. So it was voted for by Democrats at that time and opposed by Republicans. One of the reasons that made it out of the House then, as opposed to trying, in my opinion at least, as opposed to trying to correct the issues, is that in early November, the Democrats lost the majority in the House. And so once, because they had two members that ran for mayor in their particular jurisdictions and won, and so they had to step down from the House, which caused the Democrats to lose their 2-vote majority, which meant that for the Democrats to get anything passed, it needed to occur before those two individuals left, and this made it through. And right now, at least, it has not made it out of the Senate. It doesn't appear to have the same sort of impetus that it had in the House, but it is still pending, and it does appear to have it does appear to be a part of a green energy policy that is being promoted in the state, largely by the Democrats. One thing I wanted to mention about it is that this has a sort of like a double secret probation. The Homeowners Energy Policy Act has what I called here at least a double bonus invalidation. Not only does it invalidate restrictions or documents, provisions and documents that might prohibit an association from declining to approve a solar panel on a shared roof, it also invalidates any provision in any homeowners association documentation that prohibits or requires the approval of an HOA for what it calls an energy saving improvement or modification. And then it defines an energy saving improvement or modification as those items that are listed on the bullet points below, including clotheslines, rain barrels, energy efficient windows, regardless again of whose obligation it is to take care of the windows, heat and electric vehicle supply equipment. And this is not an exhaustive list. It just includes these items, but it's not limited to these items. So in theory, if HB 5028 passes in its current condition, then no HOA in Michigan would have the ability to either require its approval or object to the installation of any of the items that you see on your screen. So I know that the Legislative Action Committee for the Community Associations Institute opposes this bill and has undergone efforts to try to prevent it from passing, but it's pending. We wanted you to know about it. And in case you have a position, keep an eye out, and more may be coming about this down the line, depending upon how it moves in the state Senate. So those are kind of the two big ones, the Reserve Studies Bill and the Homeowners Energy Policy Act. There are two other bills that are not likely to go anywhere, but are worth mentioning. This one, which is actually two bills put together, 4312 and 4313. These bills get introduced almost every year since 2017, or every session. So they were introduced in 17 and 18, in 1920, in 21-22, and then again in 23-24. The goal of these bills, which would generally be supportive of, would be to allow summer resort associations, which is a specific type of community association that are formed under an act that had first been adopted in 1897, if they wish to instead convert themselves into a domestic nonprofit corporation under the Nonprofit Corporation Act. Basically, the goal here would be to allow those summer resort associations who wish to do so to modernize their corporate structure by converting into a nonprofit corporation and then adopting bylaws in accordance with the Nonprofit Corporation Act. At least according to the legislative summary, the state considers that there are 43 active summer resort associations under 1897 PA 230. I don't necessarily know if that number is completely accurate, but that's the number the state is going off of. So if you are a member of a summer resort association, this may have some impact on you, but that's something that's pending. What's a little bit weird about it is that I've never heard anybody speak against this, and it's been introduced so many times that there's an effort to get it passed, but it just does not go anywhere. And I'd be surprised if it made it through this year, but there was in 2022, there was a summer resort act that did get passed. So we'll see what happens. It wasn't as significant as this, but it did make it through. So we'll see, but something to keep an eye on. And so if the Summer Resort Association bill was one that we were generally supportive of, here's one that we're opposed to. This is if the Homeowners Energy Policy Act is a dream bill for solar energy contractors, then these two acts, bills, SB 451 and HB 4837, are really contractors' dream bills. These are here because they have potential, if they pass, and I don't necessarily expect them to pass because of their content, but if they pass, they have some pretty significant provisions. At the time of contracting, an owner, and it would be an association, would need to certify, would basically need to have the funds available for the completion of the contract at the time of contracting. In addition, they would need to, if they're going to object to a dispute, they would need to give notice of, if they would make it an objection, then they would need to give notice of that objection and a dispute on payment within 10 days, and it would require payment to contractors within 30 days of being billed. From both the owner's standpoint and a contractor's standpoint who refuses to pay a subcontractor, these bills also have pretty significant payment provisions of 12% interest for non-payment. So in situations where somebody withholds payment, whether it's a belief that the work quality wasn't adequate or if funds aren't available, then in those situations, it carries a pretty significant potential penalty of 12% interest. So from a contractor standpoint, that would be great. you're ensuring that you get paid and you get your time value of money, plus a pretty good threshold, which is even above some usury amounts. But that's what's there. It is intended to protect contractors and subcontractors. We generally are in opposition to this. A similar bill was introduced in 2022. It didn't go anywhere in 2022 and died at the end of that legislative session. I'd like to think the same thing is going to happen to this bill, but it is pending, and so just wanted to make everybody aware of it, and in case for whatever reason it is ultimately successful. But again, it is something that's pending, so we'll see what happens with it. So those are the bills. Those are the federal initiatives that we're in tune to. Those are the acts that have been adopted or that have passed that we wanted to bring to your attention. Those are the pending bills. In addition to those things that have already been introduced, there are a couple different items that have not necessarily been introduced in the 2023-2024 session, but are significant enough that we wanted to talk about. And first amongst those is, and if you've attended this session in the past, you kind of know all about this, is the Marketable Record Title Act. In 2018, the Marketable Record Title Act was amended. And in large part, those 2018 amendments create a risk. At the time, they created a risk that for homeowner associations and potentially condominium associations with restrictions that are older than 40 years, then those communities may need to either record a notice of a claim of interest or establish that the equivalent of a claim of interest has been recorded in a chain of title over the past 40 years, or risk that their restrictions be deemed extinguished by the Marketable Record Title Act. So that's the risk. Now, at the time the 2018 amendments were adopted, it contained a 3-year sunset, so it was a March 2021 deadline. In 2022, that deadline was extended, but for our purposes, it was extended to just under 2 months, or just over 2 months from now, to March 29th, 2024. The significance being is that if you have an HOA, especially, or even potentially if you have a condominium that hasn't had a recorded amendment over recently, if you're not in the process of submitting a notice of claim, you likely want to strongly consider doing that in order to beat that deadline, because the risk being that if there is nothing in the chain of title to provide notice of the existence of the restrictions that you may want to rely on, then if interpreted a certain way, the Marketable Record Title Act could be deemed to invalidate those restrictions. Now, there are some arguments against that. For example, in 2022, the Marketable Record Title Act was amended. In addition to extending the effective date from March of 21 to March of 2024, there was an amendment done in December of 2022 that accepted or excluded land and resource use restrictions. And I've used the terminology that we would use here, which is land use restrictions, which accepted land use restrictions from applicability of the MRTA. This has a potential benefit to community associations and could reduce the impact of the MRTA, assuming that we're successful in being able to establish that the concept of land use restrictions includes the covenants and conditions and restrictions included in most deed restrictions. As enacted, though, even with that potential benefit, the 2018 amendment does create a risk for communities older than 40 years that their restrictions could be extinguished if a notice of claim is not recorded in the chain of title. So if you have not yet begun the process of investigating the recording of an MRTA, I would strongly suggest that you do that sooner rather than later, because that effective date goes not off of the date that you contact an attorney to try to get it done, but by the date that it's recorded. So you would need it done by the end of, by March 29th. Just to give you a little bit of background as to where the current legislative efforts. So that's the impact of the Marketable Record Title Act. There was a bill that was introduced that was intended to be a comprehensive fix for the Marketable Record Title Act to address this concept. However, it didn't address homeowner associations, and it didn't benefit homeowner associations in a way that was materially different than as the act currently stood. There is a we do expect legislation to be introduced in Q1 with pretty soon, actually, that would potentially exclude homeowner associations and condominium associations from the Marketable Record Title Act, but that bill has not yet been introduced, and it appears to have been kind of caught up in a log jam that exists because of the tie that currently exists in the House between Democrats and Republicans. It does not currently appear that either party is being incredibly cooperative with the other. And so as a result, even issues that you would like to think would be potentially bipartisan have to a certain extent appear to have ground to a halt. We are optimistic, though, that something will be introduced. We've also heard that there will be another 6 month, there will be a 6 month extension introduced to move the effective date out from March 29, 2024 to the end of September of 2024. That is supposedly forthcoming. I am not very optimistic about that, though, and the main reason I'm not very optimistic about that is because, in my opinion, it's likely too late for that to benefit those that would be caught by the March date, because you would need 90 days for an effective date of an act for an act to be, once it's adopted, to go into effect, which would take us outside of that March 29, 2024 date. And I also haven't seen the bill yet. So, but those are a couple things that are potentially coming down the pike, possibly another bill that could correct the issue from an HOA perspective, and a possible extension of the March 29, 2024 deadline. And while there was a bill introduced, I didn't go through it here, mainly because it appeared to have been introduced almost as a poke in the eye of those that were trying to move forward with it, move forward with actual changes to the MRTA. So that's the MRTA. Long story short, still pending, still trying to be fixed. And if you haven't yet done so, take a look at submitting a notice of claim if you have an older association, older than 40 years. All right, so lastly, what I wanted to cover were some potential future initiatives that to kind of take a look at that may come in, maybe in 2024, maybe not in 2024, but these are some things that I know that we're looking at. One is the legislation directed towards the anti-lawsuit provisions and developer drafted documents. These are especially prevalent in condominium documents drafted within the past 5 to 10 years. If you are a newer condominium, then you may have these and you may have seen them. Basically, what these provisions tend to do is to say that in an effort for full disclosure, a board of directors is not authorized to file a lawsuit against anybody, including a developer, conveniently, unless you are able to get a certain threshold vote of the community before proceeding. The goal of these provisions is to try to make it difficult to authorize a lawsuit against a developer. And the legislation, were it to be introduced, would attempt to invalidate that perspective so as not be able to allow that type of provision to prevent a board from suing a developer. Part of the rationale here is to prevent the possible impact of the tight statute of limitations applicable to boards of directors transitioning from developer-controlled condominiums to owner-controlled associations. So we'll see what happens with that. We are currently looking for a sponsor, and optimistically, we'd like to see something in the first part of 2024. Realistically, if it doesn't get introduced until the second half of 2024, it's probably not likely to move because of the end of the session would be at the end of 2024, but we'll see what happens. Condominium termination, this is another provision that we're looking to try to clean up. This is something that under the Condominium Act, if a community association would like to terminate a condominium, then even if the developer is no longer in the picture, the Condominium Act currently requires that the developer consent to the termination before the termination can be effective, even if that developer is no longer involved in the project. So what we are looking at is the possibility of legislation that would remove that developer consent requirement if the developer is no longer involved in the project. This is probably a little bit of a longer term concept, definitely behind the MRTA and reserve studies, but something to look for as a potential down the line. And then the last item I wanted to mention, which has been kind of big in prior years, is that it's the concept of short-term rentals. In the 2021-2022 session, and even before then, there had been legislation introduced that attempted to tackle from a pro short-term rental concept, the concept of trying to limit what municipalities can do with respect to zoning and their ability to restrict short-term rentals. The implication potentially being that that language could potentially be used by individuals against homeowner associations in an effort to try to promote the use of short-term rentals, even in the presence of restrictions that otherwise could be applied. For example, the definition of residential use or anti-commercial use provisions. What was kind of interesting was that nothing on this front occurred in 2023. We kind of expected that they would make another go of it in an effort to try to get that legislation through, but we really didn't see anything of note happen in 2023. So we'll see what happens in 2024. It is a possibility that it still comes to pass, that something like that comes down the way, but it at least hasn't happened yet. So we'll keep an eye out and see what happens with it though. So at least with respect to the things I had wanted to talk about and what I wanted to introduce, that's what I have for you. We have the different concepts on the federal side. We've got the Fannie Mae, Freddie Mac underwriting guidelines that have been updated. We've got the Corporate Transparency Act, and then we have the introduction of the Making Condos Safer bill at the federal level. We have the two acts that had been adopted in Michigan. That's the gender identity and sexual orientation protections, and then the super exciting Brownfield Redevelopment Act. Then we have the pending bills on reserve studies, energy efficiency items, including solar panels, contractor payments, and the some resort associations. And then lastly, we've got the, even though not introduced as a bill yet, from our perspective at least, the Market Record Title Act, and then the two potentials for the developer provisions, including termination and anti-lawsuit. So at this time, if you're muted and would like to ask a question, go ahead. I see that I have 6 in chat, so I'll probably actually turn to that first. So I've got a, okay, so Tiffany asks, is there a form for board members to complete that we can provide ahead of annual meetings? And is there any plan for the mass exodus of board members who don't want to share their information and ultimately communities don't have new volunteers? So there's kind of a lot bundled up in that question. I understand it. So basically, I think, Tiffany, what you're getting at is, and I'll answer it kind of from a legislative side. From a legislative side, there's nothing pending in Michigan on this that would correct or address the problem of not being able to get volunteers or directors resigning in place. If you know, that's on the legislative side. So on the legislative side, I can't necessarily help a lot with respect to what's going on in 2023 and 2024. On a practical side, if you have a board where you have a large number of individuals who are resigning, there are certain tools that you can use to try to get that board restocked with volunteers. It does assume that there are volunteers who are willing to step up and take those positions. In addition to the ordinary election of directors at the annual meeting, you also have the possibility of the really a power of appointment, which would be if you have an individual who has resigned mid-term, and so you have a vacancy, then you'd have to look at your bylaws on this, but you most likely have the ability to directly appoint by an election of the board, appoint somebody to that position to fill the term until its end, and you can have a vote at the annual meeting. There are, boards do have obligations. That's not necessarily sharing of information, but of making information that corporate information available to owners that ask, and directors are entitled to information they'd be entitled to in their capacity as a director. To a certain extent, though, your underlying question, at least as I am kind of reading it, is how do you solve the question of apathy within some communities? That's much more difficult to answer. Ideally, you can, maybe reduce the quorum to try to be able to kind of match that level of interest. But as most people know on the call, communities will often rise and fall with the level of engagement that the community has. But on your specific thing, I can't help you so much with the legislative side, but appointing people to vacant positions is something that can be used in order to get a board filled to at least be able to function.
So can I just clarify a little bit what my question was?
Yes, sure.
So I know there were a few layers, but as far as it relates to the changes in transparency, when people have questions about how much of their information will be available or how much they're required to share,
So, I see what you mean.
My concern is that people will not volunteer if they feel like they have to now be an open book.
We have actually in 2024, we have begun signing up clients who would like to submit the information and like to do the CTA form. It's done online. It's something like 51 questions, if I remember correctly. We can assist with it and we can help do it. We have an online form. Our form at least is online that would be used to obtain the information to be able to submit that. It is the case though that if individual board members do not want to share that information, that's going to be a big problem because it is required to be submitted in order to be able to be considered a valid CTA submission. So from a form standpoint, we have an online form because it's an online portal that's used by FinCEN. At least from a plan for the mass exodus of board members, we've tried to push out the date. We're trying, CAI at least has tried to get the FinCEN to not apply this to homeowner associations, but it does apply. And the plan would be on a case-by-case basis to explain the information needed, why it's needed, and trust that owners in a community would still be willing to serve, even if they have to provide that level of information.
Thank you.
Okay, so the next question is still on CTA. CTA filing is required every year, yes. And so I guess so should we file it after an election of directors, whether there's a change or not? And who prepares the filing? Association of Property Manager Council, where to find out how complicated the filing is. In theory, you can do it. You do not need to do it if you retain somebody else to do it. We are doing it currently on a flat fee basis currently at least. We are doing it on a flat fee basis at $500, at least for 2024. It's not incredibly complicated to conduct the filing. Kind of as Tiffany was alluding to, a lot of it is getting the information ahead of time that would be needed in order to be able to file it. As far as the timing of it, since it is every year, and this kind of goes to my comment at the beginning as to when to do it in connection with 2025, is that once you conduct your election of directors for 2024 and you're locked in for who your officers and directors are for 2024, it does appear to make sense to go ahead and do the filing at that time. That way you would have it done before 2025. Now, if there is a change, for example, once there's an election of directors in 2025, you would then need to file the documentation with FinCEN documenting that change. And then as far as finding out how complicated the filing is, there is FinCEN does have a portal that is up and the questions are available. Basically what you're going to need to know is you're going to need to know specific information about the individuals that are on the board. Date of birth, name, there's specific information that will need to be obtained. Offhand, of course, I'm not recalling the specific items themselves, which I know is not incredibly helpful, but it does need to be, there's certain information that would need to be collected, both about the board members and then for new associations about the incorporator, if there's a new corporation being formed. And we would, if you're going to have elections, my suggestion would be, which you're going to do in 2024, is shortly before the elections, again, to what Tiffany was alluding to, is to try to get a little bit of a handle as to what would be required. And then after the elections, relatively as quickly as you can, submit that information. In 2024, you probably have a little bit of time to do that. But in 2025, especially, that information is going to need to be submitted within 30 days. So you'll need to be relatively on top of it. Okay, the next question is from Nate with respect to the reserve study bill. Regarding the reserve study bill, is there a de minimis budget size? For applicability of the bill, the budget size is $20,000. So the reserve study bill would apply to those communities with a budget of $20,000 or more. Does the allowance for changes made to the funding plan mean you can deviate from the study recommendation if you justify it? Generally, yes. So the concept is that it's really on a notice side, so that the funding plan is done in accordance with, but it doesn't need to be strict. It wouldn't need to be strict adherence to the reserve study itself. And so as long as you have a reserve study funding plan, excuse me, and then you can match up your rationale as to why the reserve funding plan is set up the way it is with the reserve study and be able to justify it, that's the goal behind it. And the idea is once that is communicated to co-owners, then in the political process, the co-owners would accept your rationale, would accept the rationale of the board, or may feel differently and want to go in a different direction. But it doesn't mandate that something specifically be done with respect to amounts, or even that it be done under full funding under the reserve study. It's just that the reserve study must be considered when coming up with the reserve funding plan. Are there penalties to or for boards that will not acquiesce to reserve studies? So Tiffany, I guess I would ask, do you mean to boards that would not get a reserve study, or boards that won't come up with a funding plan in accordance with the reserve study?
Honestly, a little bit of both.
Okay.
Especially at maybe it's just me, but especially over these last couple of years, more than in the past, boards are refusing to raise dues, fund reserve accounts, do all of those proactive things. And so is there a penalty of some kind to them that will require that they not just consider these things, but actually act on them?
Well, it would be similar to any other violation of the Condominium Act, in that another co-owner would be able to file a lawsuit to force the board to do a reserve study if it hasn't been done. That's one aspect, and in theory, at least, if an existing board has an obligation to conduct a reserve study and refuses to do it, then in theory, at least, it could open up those board members for a potential breach of fiduciary duty, in theory, at least. And then you have the potential remedy of being able to file a lawsuit to force the board to do that. You know, and those are the tools that are available if a board refuses to do what the board is supposed to do. With respect to funding, on the funding side of it, really on the funding side of it, if reserve study has been obtained and the board comes up with a reserve funding plan and the board is not funding it to the letter of the reserve study, at least as the bill is set up, the expectation would be it primarily be a political response. And that as long as the community is given the information, then the outcome of the voting process would decide whether or not the community feels that the funding plan adopted matches up with or is consistent at least with the outcome of the reserve study. It could be the case, though, that if a funding plan is markedly deficient, so that if there's no effort to abide by the reserve study or to match the reserve study's expectations on funding, and there's a complete reliance on special assessments or borrowing to the really to the exclusion of a reserve fund, then in that situation, regardless of the political response, meaning even if those board members still stay in power, it is possible you could have a co-owner take the position that those board members are not abiding by their fiduciary obligation to come up with a reserve funding plan in accordance with the reserve study. But it is attempted to be set up so that there is some flexibility given to the board in making those types of decisions. I did want to back up for 1 second. This goes back to the Corporate Transparency Act, just with respect to the information that would be required for a beneficial owner. Under FinCEN, the information that you would need would be the name, date of birth, address of the beneficial owner, along with the identifying number and issuer from either a driver's license or passport or a non-expired identification document issued by the state. So that's the type of information, and that's the information that would be required. I just earlier said that I couldn't remember at the time, but just wanted to convey that in case you're wondering. Okay, regarding reserve studies, can an association do its own reserve study, or must it hire an outside firm to do it? One of the things that the reserve study bill does is it sets the minimum standards for conducting a reserve study. And it does identify who those individuals are who are qualified to conduct it. And those individuals will need to have had either there's a certification from CAI, a licensed architect, a licensed engineer, or based on experience, if they've done a number of reserve studies, they'd be able to do it. So in theory, if you have somebody within your association that meets the criteria required in order to be qualified to conduct one, they would be able to do it. But if you, which I don't expect, but if you don't have somebody within your community that satisfies those qualifications, which is going to be most common, then you would need to retain somebody who's qualified to conduct it. And so while it's theoretically possible, you can have somebody do it. In most situations, you will likely need to hire an outside firm in order to be able to meet the qualifications required by the bill, assuming it passes. Okay, so there's a comment by Nate with respect to short-term rentals. I think what you're doing is, hey, Matt, why don't you define short-term rentals for us so we know what you're talking about? And as a general rule of thumb, short-term rentals, yes, they tend to be 30 days or less. That's not an unfair characterization. And in some ordinances, that is what is specified. And in some governing documents, that is what is specified. That tends to be a decent threshold, but it's not necessarily the end-all be-all. And then as far as the rest of your comment, but rentals 31 days or more are not addressed by law, that's really going to depend upon the specific ordinance that's in play. Some ordinances address long-term leases and address long-term rentals, in which case those municipalities' ordinances would apply. And some municipalities have both short-term rental and long-term rental type ordinances. So I would be careful about taking that concept universally across all associations, because it's going to, across all municipalities, is going to depend upon where you're at. Can we get a print of the 19 slides? Happy to distribute it. If you'd like a copy of it, my email is on the screen. That's mheron, or at least it should be on the screen. mheron@herzolaw.com, mheron@herzolaw.com. If you send me an email, I will respond and send you a copy of the slides. So Okay, so this is with respect to compliance with the CTA. Here's another question. We have 4 elected positions for our homeowners association. We have had to list some directors on LARA. Can we just list the 4 elected on the CTA? I know on LARA, you only get so much space in order to identify your officers and directors. And, communities with a large number of directors often have to manipulate the information that's being submitted to LARA. Whatever you're submitting to LARA is completely independent and separate from what the Corporate Transparency Act is requiring. The Corporate Transparency Act is going to require that all directors and all officers are identified and listed as a beneficial owner. And so if that's just 4, then that would just be that 4. If there's 7, then that would be 7. It would really just depend upon who those beneficial owners are. Melissa, okay, so Melissa says, so does the reserve plan proposed by the board require a vote of the owners, or is it a board decision? If the bill passes, it hasn't passed yet, but the reserve funding plan would not need to be voted on by the community. It would be much like a budget is treated by most associations. The reserve funding plan would be adopted by the board. Now, the board would be obligated to provide that funding plan to the community so they are aware of it. But the bill as currently drafted does not give the community the ability to vote up or down that particular funding plan. What it does try to do is, on the political side, give the owners the information that may be relevant to them in determining whether the board that comes up with that funding plan is the board that they want to have in position. Okay, and then Sally asks, if the reserve study states that chimney tops need replacement, does the board have the capability to set a yearly plan to do a certain number versus all at once? In general, I mean, Sally, what you're asking is yes, is how the board develops, how it's going to make improvements is generally going and make repairs over time. Is one is going to be dictated by what your documents say, of course. That's kind of a catch-all that I've got to throw in there. But the board's going to have some flexibility in how it makes the updates to, and how it repairs and replaces those aspects within in the community. Now, one thing to be careful about is that most reserve studies are not necessarily going to go into the minutia exactly of this thing, this unit needs replacement, this thing here needs it. What reserve studies are intended for is to give the association information about what the expected useful life is left of the major capital assets of the community. And then at the end of that useful life, what the cost would be to replace those things. And so it's not necessarily saying this unit's chimney needs replacement or this unit's deck, but it may be saying the decks are in need of repair, the chimneys are in need of repair, and have an expected life expectancy of 5 years or 10 years. That type of information, with the goal being that if the board knows what the true cost would be to replace everything, and the board knows what the expected life expectancy of those things that need to be replaced are, then the board can come up with a funding plan to get it done and have enough money at the time that asset is expected to be in need of repair. And there will be some flexibility as to when that takes place. And the further out in front you're able to do it, and the more advanced notice you give your communities, probably the more flexibility you'll get. But you will get some flexibility for that. Okay, so Melissa asks, where do we go to file the CTA for 2024? FinCEN does have a portal. There is an online portal that they have. I don't have the link readily available. I know what we are doing as a firm is we actually internally have set up a system to do that for clients that want us to. And if you'd like to have that done, feel free to contact me after the call, and I can walk you through that and direct you to the, we have a couple paralegals that are working on that specifically. If you want to do it on your own, FinCEN has set up a portal through which all submissions need to be submitted. Joe has probably the best question of the night. Joe says, "Thank you, Matt. This was very informative. I look for the next one." So no question, but thanks, Joe. And then, so those were the questions that I saw in chat. I tried to do my best to answer those. If there's anybody that has a question that either wasn't addressed in chat or they waited for, I'm happy to try and answer it if you want to just ask it. All right, well, I wanted to thank you for attending. Hopefully you found this helpful and useful. If you have questions afterwards, again, feel free to email me, especially on CTA. Thanks, Nate, for submitting that. That's exactly that's the link to look at. Just so you know what Nate has put into chat, the link for purposes of getting you to the beneficial owner information site, including the portal. And then if you want a copy of the webinar, please just send me an email and I'll be happy to send it to you. So thanks again, and have a good night.
Thanks, Matt.
Yep, see you, everybody.
Thank you.
Thank you, Matthew.
He acknowledged me. I says, "Thank you, Matt. This was very informative." He goes, "Well, Joe, thank you very much."
No problem. Have a good night. See you guys.
Hey, Matt,
Good catch.
I'm not seeing where the link is to file the CTA.
Hold on one second.
Oh, sure. Now I get the big one. How do I?
Can I email you and ask you for that